Okay. Heard Mr. Gogoi, learned counsel for the petitioner, and also heard Mr. Hendik for the respondent number. Respondent number 1, Mr. Singh for
Respondent number 2 and 3.
respondent number 2 and 3. Mr. Gogoi submits that he has the instruction not to press this matter. Accordingly, taking note of the submission of Mr. Gogoi, learned counsel for the petitioner, this is stands closed.
Items for motion. Item number 2.
Now, this is an application for transfer of a proceeding from court of MSC Tribunal Gauhati to the place of my lord, to the tribunal where the authorization arose. So, my lord, at this stage, Lordship may issue notice because, my lord, I am relying on a decision and a settled position of law, the convenience of the parties. Convenience of the parties means, my lord, all the parties. Here, claimant, witness, my lord, the respondent, and all are the resident of Gauhati where accident took place. So, Lordship may kindly examine this matter.
Heard Mr. Kukelso, learned counsel for the petitioner. This petition under Section 24 of the Code of Civil Procedure is preferred by the petitioner for transferring MSC case number 1775 of 2025 pending before the member motor accident claim tribunal number 3, Kamrup M. Gauhati, to any other motor accident claim tribunal nearest to the state of Arunachal Pradesh, preferably
MSC
Vishwanath Chariali or Lakhimpur. Where is the petition and the documents placed on record? Let notice be issued to the respondents returnable in 4 weeks, step by speed post and also by usual process within a come to the list after 4 weeks.
My lord, I am praying for, my lord, some, my lord, interim order.
At what stage the case is pending now?
My lord, just, my lord, notice was issued.
Okay, on next date we will consider your pair.
My lord.
Interim pair of the petitioner will be considered on next date.
My lord. Okay.
Number 6.
Lordship, my senior is on legs, Lordship. Matter may be taken up after some time.
Item 7.
May it please your lordship. My lord, what happened, my lord? In this matter, by suppressing the fact that the respondent has been suffering from cancer, she got married to the petitioner. Marriage was solemnized on 5/3/2021, and in the next month only, the petitioner came to know that she has been suffering from cancer, and that ailment was suppressed before solemnizing the marriage. My lord, thereafter, your petitioner took the respondent to Chennai for medical treatment, my lord, and on that process, he spent near about 12 lakhs rupees, my lord, and thereafter he filed a divorce case in the year 2023. Up to 2 years, he was looking after the respondent, in spite of the fact that she suppressed about the disease cancer, my lord. And now, my lord, when he
Mr. Boisho, you see, the maintenance was granted under Section 24 of the
dependent
Intermarriage
right,
Act.
my lord. Yes, my lord. Section 24, during in the death proceeding, under Section 24,
Maintenance pendant light.
maintenance pendant light. My lord, my kindly come to impugn order, which is at uh, page starting from 129, page 130, my lord. My lord, what the respondent prayed for, kindly see the non-application of mine, my lord. The respondent praying for granting maintenance pendant light of rupees 25,000 and a lump sum of rupees 5,000 only for expenses of the suit. And what that trial court given at page 132, the last paragraph, the respondent has no source of income and she is also to bear her medical expenses for her treatment. Hence, considering all the petitioner is directed to pay monthly maintenance of 10,000 only per month to the respondent from the date of filing of the instant petition till disposal of the case, and 25,000 towards the cost of the proceeding. Why not? That shows that non-application of mine. And
No, how?
It
How?
5,000 was paid for cost of the case, madam.
Maybe whether the court is not entitled to increase or decrease it.
My lord, agreed, my lord. But
Yes.
kindly consider that the trial court below failed to consider that I have spent 12 lakhs of rupees for her treatment.
2025 passed by the learned district judge Pukrajar. It is to be noted here that by impugn order dated so and so, the learned trial court has directed the petitioner herein to pay monthly maintenance pendant light at the rate of rupees 10,000 per month to the respondent from the date of filing of the petition till disposal of the case, and also directed to pay a sum of rupees 25,000 towards the cost of the proceeding. Mr. Boyce, learned counsel for the petitioner, submits that the respondent herein got married with the petitioner, suppressing the fact that she was suffering from cancer. And since the marriage, the petitioner herein has spent more than rupees 12 lakhs for treatment of the respondent hearing. And thereafter, the respondent had instituted. Who has instituted that proceeding?
My lord,
The present petitioner.
Present petitioner.
Submits that the present petitioner thereafter had instituted one proceeding before the learned trial court for dissolution of the marriage. In the said, no, while the said petition is pending for consideration, the petitioner has filed another. No, the respondent herein had filed another petition under section 24 of the Hindu Marriage Act. And the learned and right for granting maintenance pendant light and also the cost of the suit. No, cost of the suit. No, and also a lump sum amount of rupees 5,000 being the cost, but the learned trial court has granted a sum of rupees 25,000 being the cost of the suit, which indicates non-application of mine by the learned trial court. The submission of Mr. Boyce needs further consideration. At this stage, notice be issued to the respondent returnable in 4 weeks. Step by registered, speed post and also by usual process, we can wait from today. List the matter after 4 weeks. Is there any interim pair?
My lord. Yes, my lord. Till returnable date, my lord.
Interim pair of the petitioner will be considered on next returnable date, not today.
My lord, one thing, my lord. In paragraph 3, the date of the marriage was wrongly typed. I may be allowed to correct.
Okay. Mr. Boyce, learned counsel for the petitioner submits that in paragraph number 3 of the petition, the date of marriage has wrongly been mentioned. Then he prays for granting him permission to correct the same. They are allowed.
Obliged, madam.
Item number 8.
May please your lordship. Here, my lord, we have challenged one order of the, my lord, learned, passed by the learned civil judge, my lord, Nagaon, my lord, whereby the petition of the present petitioner, that is their defendant, my lord, in the title suit, the petition was made for commission for comparison of signature in the documents, my lord, under section 45 of the Indian Evidence Act, and it was filed under Rule 26, Order 26, Rule 10A, read with Section 75E of the CPC, my lord. And that petition application was rejected. So this is my lord, this my lord, order we have challenged, my lord. As per my
But
lord,
madam, you see,
What?
when the comparison is permissible,
my lord,
when the comparison is permissible,
my lord, in the seal deed is a registered seal deed is of 1996, my lord.
that's all right. But whether there is admitted signature,
Yes, my lord, it was admitted, my lord. This
Where?
document was an admitted document because there was never any dispute, my lord, and the title suit
no,
was
no,
filed on.
document is not dispute. That is a different matter. But whether the signature or the thumb impression is admitted.
That is why, my lord, here the petitioners, my lord, the defendants made a prayer for expert, my lord, comparison by expert.
Let notice go at this
commission, my lord.
hardness as we showed already, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 16/1/2026 passed by the learned. Civil Judge Senior Division Nagaon in title suit number 14 of 2016. It is to be noted here that by impugn order dated 16/1/2026, the learned trial court has dismissed the petition number 1225 of 2025 filed under order 26 Rule 10A, read with Section 75, we can make it small e of the CPC. Where is the petition and the documents placed on record? Let notice be issued to the respondent, returnable in 4 weeks, step by speed post and also by usual process within a week from today. List after 4 weeks. Interim period of the petitioner will be considered on next that. 4 weeks. After some time.
Item 4. Orders. Item number 23.
Who is for the petitioner?
As far as Mr. Suzy.
Pardon?
Mr. Suzy does.
Yes, it does.
Yes, that's.
You are for the respondent number?
For respondent number 3, legal has or respondent number 3.
Okay. Yes, after some time, you inform me.
Lordship, the service is complete. So.
Service completed.
As per our instruction.
As far as I know, respondent number 1 and 2 has appeared. And already, we have already filed a follow number for respondent 3A and 3B to Z.
How many respondents are there?
Total 3 respondents, and 1 and 2 they are appeared. And I will pay for respondent 3, 1, 3, 2, 3, 6.
You are for 3A to
3, 1, 3, 6.
6.
We can also respondent number.
Okay, service completed then. We'll release the matter for admission hearing. Heard, Mr.
A. Mishra on behalf of Estas.
Learned Counsel for the petitioner. And Mr. Bhakhtir for respondent number 3A to 36, no, 3F. And Mr. Learned Counsel appearing on behalf of Mr. E.R. Sikdar. Learned Counsel for the respondent number 1 and 2. It is submitted at the bar that service in this matter has been completed, and as such, the matter may be listed for admission hearing.
First week of April.
Accordingly, it is provided that registrar list the matter in the first week of April for admission hearing.
Interim is there.
Interim may be continued.
Okay, interim order pass earlier shall continue.
First April. Pending item 38.
This matter leads to civil division IO, my lord.
Hmm.
What happens, my lord? The petitioner filed the counterclaim, my lord,
Hmm.
not on the date of filing of the written statement, but on the next date, my lord, immediately next date, my lord. But trial court rejected on the ground that it will change the nature of the litigation. I took your lordship to the last, my lord, page 28, my last paragraph. Upon perusal of the print, it transpired that this is a suit for declaration of right title and right and title by virtue of adverse possession, and on the other hand, the defendant number 1 filed the said counterclaim paid for rejectment of the plaintiff along with prayer for recovery of area rent and concurrent rent. Suit for declaration of right title and virtue of adverse possession cannot be tied together with a counterclaim for rejection and eviction and recovery of area rent. Current rent is allowing such a counterclaim will fundamentally change the nature of the suit. The case filed by the plaintiff for adverse possession, my lord, the defendant filed a counterclaim for rejectment of the plaintiff on the ground of failure to pay rent, my lord. It is not a, my lord, amendment of the pleading, my lord. Learned Trial Court has clearly there like the of
No, there was a delay in filing the counterclaim.
or only next date, my lord. First date WS was filed, on the next date I have the plaintiff has the defendant handed over both the documents to the learned lawyer, but learned lawyer could not file the same on the same date. I have stated that made the statement in paragraph, my lord, 3, page 3, my lord, of the revision petition, my lord. In due course of time, the petitioner entered appearance and filed the written statement on demand, but could not file the counterclaim on this. It may be stated here, though the counterclaim was handed over to her counsel on the same date, but same could not be filed by the learned advocate. I have handed over the advocate, my lord, but it was filed on the next date, my lord. So may I present, my lord, notice be issued, my lord? I have relied on 4 judgments, my lord, that were mentioned in my written argument, my lord, page 23, my lord. 2 judgments of this honorable court and 2 of Supreme Court, my lord, where it was mentioned that must be filed before the framing of the issue. That is the correct. Page, my lord, relevant is, my lord, page 25, paragraph 6, my lord. Last line, my lord. In any case, not after framing of issue. And both the judgment of the Honorable Court also state the same thing, relying on this judgment matter. And they have other criteria is also there, my lord. Period of delay and other things are there, my lord. Para 9, my lord. Page 26, also same things. Counterclaim cannot be filed after framing of issues, meaning thereby that no bar in filing and accepting the counterclaim filed prior to framing of issues. My lord, I have deposited the court fee also, my lord, along with the counterclaim, my lord. The counter, in fact, my lord, the plaint is not maintainable, my lord. They have paid only court fee of rupees 11, my lord. I took to answer your lordship to page 8, copy of the plaint, my lord. Suit for declaration of right title and by virtue of adverse possession and for consequently relief of permanent injunction for the purpose of court fee and jurisdiction of the court, the suit is valued at rupees 100. Well, though the property is.
So what is the reasoning given by the learned trial court?
Well, I have read the lordship to the page 28, last paragraph. As per the learned trial court, my lord, it will change the nature of the suit. That is the case. May I read, my lord? Upon perusal of the plaint, it transpired that this is a suit for declaration of right and title by virtue of adverse possession, and on the other hand, the defendant abide the said counterclaim paid for ejectment of the plaintiff along with prayer for recovery of area rent and concurrent rent. Suit for declaration of right and title by virtue of adverse possession cannot be tied together with a counterclaim for ejectment, eviction, and recovery of the area of rent, as allowing such a counterclaim will fundamentally change the nature of the original suit. That is the ground. And in the objection, that ground was not taken. In the objection filed by the plaintiff, only ground was taken. It was not concurrently filed. That is not concurrently filed with the WSC. But the learned trial court cooked up another story, which is not neither case of the defendant, neither case of the plaintiff.
Okay, you are relying upon this decision of Supreme Court?
Supreme Court, my lord.
Point number 6.
My lord, page 20, paragraph 6, man. And other two judgments are our High Court is also there, my lord. I have enclosed. This is the copy of the judgment.
Okay, no, it is already,
My lord,
it is on the record. These decisions are already on the record.
my lord.
Okay, we'll say and we'll pass order if possible. We'll dispose of the matter today itself.
My lord,
We'll dispose of the petition today itself without issuing notice.
my prayer may be allowed. That is my prayer.
We'll see. We'll consider the paragraph number 6.
6, all full argument, written argument is
Oh,
there.
yes. Okay.
Pending item 6, promotion.
May I please, Lordship?
Yes.
Lordship, it is in order. It is passed on the basis of an application filed under section 10 of the CPC, filed by the petitioner. So there is a two suits, Your Lordship. Title suit 15/2017. That suit was instituted by the predecessor of the present respondent, number 1 and 2. for declaration and injunction.
Mm.
And in that suit, your lordship, my salary has been challenged.
Mm.
And along with me, there are other 5 defendants.
Mm.
Because defendant number 2,
Mm.
he was arraigned as a party from whom I purchased it. And when we have entered appearance, we file a return statement. That means the defendant one file a return statement stating that I have purchased the land from the defendant number 2 by registered sale deed number so and so,
Mm.
that is which is under challenge in this suit. And my vendor, that is defendant number 2, he purchased the land in the year 2013.
Mm.
So this is the sale deed number so and so.
Mm.
So instead of amending the plaint, your lordship, they could have amended the plaint because already the defendant number 2 is a party.
Mm.
So subsequent suit has been filed. But in that suit, I have not been arraigned as a party. Is subsequent suit, that is 16/2017. In that suit, I have not been arraigned as a party as defendant. So when we have come to know about the pendency of the subsequent suit, I filed an application to implead myself as a party in this suit as defendant.
Mm.
So I have been impleaded as defendant number 6.
Mm.
So after going through the copy of the plan, I have come to know that the statements made in the earlier suit 15/2017 and the statements made in paragraph number 16 made in the plaint of title suit number 16/17 are ditto. Ditto. My allegation has also been headed. Land property is same. Parties are same. So that is why I filed an application. I being impleaded, subsequently impleaded, I filed an application. Section 10, we have taken the plea in the return statement also.
Mm.
I filed a return statement in this issue. So it is a same subject matter, same properties. So that is why that to be stayed.
Mm.
But learned trial court says, no, although suit is different to suit and just subsequent one, and the sale deed challenge in both the suits are different.
Mm.
So that is why this is not liable to be stayed.
Mm.
He could have aided because he made in the earlier suit, the plaintiff aided myself as well as my vendor in the said suit, challenging my sale deed. And when I have filed a written statement stating that my vendor, defendant number 2, purchased the land by registered sale deed number so and so from your predecessor or so and such. So instead of amending the plaint, file second suit.
Mm.
So this is the impugned order, your lordship. The
No,
impugned order at
Mr.
page 7,
Mr. Bhuya,
lordship,
you say, though the parties are same,
lordship,
plot of land is same,
same,
and the subject matter is also same
same,
for cancellation of sale deed,
same,
but the sale deeds are different
sale deed are different.
and the cause of action is different.
Cause of action are different. Cause of
Transaction
action,
is
yes, earlier,
different.
in the earlier cause of action is different,
Transaction is different.
different,
So it will not satisfy the requirement of section 10.
lordship. So at base, your lordship, both these suits to be taken together. Both these suits.
Mm.
Because parallelly, lordship, if a judgment passed in the subsequent suit,
Mm.
it will affect the earlier judgment also.
No, is it your pair in this petition?
No, yet that not there.
Then,
So that can be done. The earlier my application was. it is
okay, we will
section 10.
record your submission.
Lordship,
We will direct the trial court to consider your pair
lordship,
to try both the suit together.
together,
But we are dismissing this petition.
lordship.
Next item.
Number 24.
Yes.
Your Lordship, we have filed an application for condolation of delay of 23 days as on 3/6/2024, filing a civil revision against impugned judgment and order dated 9/2/2024. And in paragraph 2, it is mentioned about the delay.
Whether the counsel for the opposite party present today? Other side? Correct. A respondent on R4. Call কৰি দিব পাৰিব। Wait for some time.
Items 25 and 26.
Mr. Lordship. Lordship, in this matter, the service has been completed, Lordship.
Pardon?
In this matter, the service has been completed, Lordship.
Service completed?
Yes, Your Lordship.
Okay.
Can I fix the matter in the admission column?
Heard, Mr.
Argument.
Learned counsel for the petitioner and Miss M. Not learned counsel for the respondent. It is submitted at the bar that service in this matter has been completed and the matter may be listed for admission hearing. Accordingly, it is provided that recessal list the matter in the column admission hearing after 1 week or 2 weeks.
Any day, Lordship.
Okay,
2 weeks.
after 2 weeks.
Lovely.
Same in 26 also same.
Lordship, kindly fix another day, Lordship. My senior will be out of station on 26.
Okay.
27.
27.
Item 27.
Pleasure, Lordship. Service is completed. Service completed. The matter may fix for admission. Heard, Mister, your name, please. Your name?
Yes, I can.
Learned counsel for the petitioner and Ms. Chaudhary for the respondent. It is submitted at the bar that in this matter service is completed and the matter may be listed for admission hearing. Accordingly, it is provided that recessal list the matter in the column admission hearing after 2 weeks. After 2 weeks. Okay.
28.
Madam, service report has not been yet received on
Pardon?
respondent number 1. Report has not been received. Office note, my lord,
Heard,
20.
Mr. Sansetti, learned counsel for the petitioner. Office note dated 20th 12/2025 indicates that service report in respect of the sole respondent is still awaited. What to do? You want to take fresh step?
Yes, my lord, I may take.
Fresh step.
Yes, my lord.
The learned counsel for the petitioner submits that he may be permitted to take fresh step upon the respondent. Where allowed, step be taken within a week by speed post and also by usual process. List the matter after
Interim
4 weeks.
may continue, my lord.
Interim order passed earlier shall continue.
Item 29 by VC mode.
Mr. Khera, you are for respondent number?
My lord, I'm assisting senior advocate,
Is assisting me as a petitioner.
petitioner, my
Okay.
lord.
Yes,
I'm
something-
assisting senior advocate Randeep Sharma, sir. my lord.
Okay. So this service in this matter is completed.
My lord. My lord, the records of the lower court were called for, of the additional district judge's court. It has not been tagged, I suppose, my lord.
Pardon?
It has not been tagged, the records were called for.
Whether record has been received.
My lord, in the last hearing, I was directed to satisfy this court as to how petition under Article 227 lies from the order of the learned district judge under Indian Telegraph Act 1885. My lord. This is
Oh, that's all right. We will consider it at the time of admission.
My lord, very well.
Let the record come.
My lord.
Third, Mr. R. Sharma. Learned Senior Counsel assisted by Mr. N. Khera, Learned Counsel for the petitioner. Mr. Gogoi, Learned Government Advocate for the respondent number 1. None appears for the respondent number 2 on call. It appears that though service has been completed, the record of trial court has not yet been received in view of the office note dated 2/3/2026. Accordingly, it is provided that SSL issue urgent reminder to the learned trial court for transmitting the record. Place the matter after 2 weeks. And also list the matter under the column admission hearing.
My lord, if my lordship pleases, my lord, may kindly fix the date on the end of March. my lord.
Okay.
On 25th March.
25th will be convenient. 28, 29, 30th.
On 27th March.
Very well. Obliged. Obliged.
So why you have referred this decision?
My lord, this is to satisfy my lord as to the admissibility of a petition under Article 227 in this case, my lord. In the initial order, I was directed by this honorable court to satisfy your lordship as to how a petition under Article 227 lies in this case, my lord.
No, is there any bar in the Telegraph Act?
No, no, my lord. In fact, it perpetuates the filing of a petition under Article 227 because under 16 subsection 5 of the Act, the order of the district judge is final. There's no provision for appeal.
Okay. Okay, you can take it back.
My lord,
You can submit it at the time of hearing.
my lord, very well.
Okay.
Obliged. my lord.
Item 31.
May I please?
Yes.
I'm for the applicant, respondent was supposed to file, objection for our delay, but we haven't received any copy. On the last 2 dates, they have taken time for filing objection.
But today none appears for them. Wait for some time, court master will inform the council. Okay.
Item 32.
May I please, your lordship? Also, forest department to take instructions, lordship, but none appears. Also, this matter was, lordship, there was a criminal appeal, lordship, order was passed. Seizure of vehicles, lordship, we are here for.
Can you inform? Okay. After some time, he will call the council.
Obliged.
Item 35.
May it please the lordship, may kindly pass over this matter for the time being. Engage counsel is on like obliged lordship.
Lordship,
As per the last order, we are required to file an affidavit in the matter. Lordship.
Hmm.
The signed affidavit, it is coming, Lordship. We are filing it during the course of the day. On behalf of the District Commissioner, Gauhati, Lordship.
So we will list the matter on Monday.
Lordship, any date after 11th, Lordship. Senior Counsel Degondadas will appear in this matter.
When?
Any date after 11th.
11th
11th of March. Yes, sir.
Okay.
On 18th March, on 20 March.
Yes.
Heard,
Much-
heard, Mr.
I here.
I, learned counsel for the petitioner. And Miss
Then we will approve.
M. Devi, learned counsel for the respondent number
5 and 6.
5 and 6. Mr. Borra for
Mr. Sibora for respondent number 2 and 3.
learned counsel appearing on behalf of Mr. C. Borra. Learned counsel for the respondent number 2 and 3. 2 and 3. Ms. Devi submits that during the course of the day, she will be filing an additional affidavit
Affidavit, Lordship.
for the respondent number 5 and 6.
Lordship.
For the respondent number 5 and 6. And she applies for listing the matter on 12 then,
Yes, Your Lordship.
12.
Yeah,
Okay. Accordingly, it is provided that rest shall list the matter on 12. Okay, ইয়াতে আৰু হেৰি
If there is a
কিবা instruction আছে নে তাত মাতি সুধিব
Lordship, can it be on 13th of March?
13th of March.
13th of March.
No, 12, 12.
20 of Monday in Delhi was. Item number
13 March.
Yes, sir. No, the affidavit file করবো বলছে তো, post on the date.
Mr. Mohanto, you are for respondent number
8, my lord.
8.
My lord, I am also, my lord, have to file one affidavit because I have already applied for certified copy of my daily report along with my lord, the valuation of the PWD. So I have already submitted application, but not copy has been not yet ready.
Okay, you may file in the meantime.
My,
That is fixed on 13th of March.
Yes, Your Lordship.
Before that,
no,
you file.
13, my lord, I am not available, my lord, 13 March. 12 and 13, 14, I will be not there, my lord. 15, 16, my
No,
lord.
no, then on 11th.
Lordship, 11th senior council is not in.
15?
15 Sunday, right? 16th, 16th.
16,
Lordship.
16th.
16th. Your
Okay,
Lordship.
16th.
Much obliged, Your Lordship.
Then we 35.
I'm sorry, my lord, I was on legs in different. Lord, service is complete, my lord, but there is no official note regarding speed post, my lord. The stay affidavit has been filed.
So, you have effected service by dusting mode upon all the respondents.
My lord,
All the
as
respondents.
per the order, my lord. 1 to 4. Basically, claimants are the prime respondents, my lord.
Pardon?
Claimants are the prime respondents in this case for this suit, my lord.
Okay. Now, at what stage the proceeding is pending?
My lord, now this is fixed for evidence on 20th March, my lord. Evidence. WS is on record, my lord, but that is not accepted. This was filed along with the petition filed praying for vacating the ex parte order. This is on record, my lord. Lordship may kindly see page 41. Written statement is also on record.
Yes.
Page 41. The impugn order, my lord. Paragraph 2. Page 41. Learned advocate for OP number 3 by filing petition so and so create for vacating ex parte order passed against it and to accept the written statement which is submitted today.
After how many days you have filed a written statement?
My lord.
After how many days you have filed a written statement?
My lord, immediately, my lord, almost after more than around 2 years, my lord, almost 2 years, my lord. It's a bona fide omission on our part, my lord, because the investigation was being carried upon, my lord, obtaining police papers, my lord, to prepare the written statement. Because we had a company, my lord, we had to.
So how do you explain 2 years?
My lord, let me get my lord, paragraph, my lord. Six onwards, my lord. Page 8. Because the case, my lord, was filed in view of the new act, my lord, where the police report has to be forwarded to the insurance company, my lord, along with the documents, my lord, collected by them. But that was not done. So that is why, my lord, independent investigation was to be carried upon, my lord, to obtain the certified copies of the police papers as well as the vehicular documents, my lord. That took time for preparing the written statement. And again, my lord, after preparation of the written statement, my lord,
No, you see,
it was sent for vetting, my lord.
Beyond 90 days, only under exceptional circumstances, it can be extended. So in your case, delay is more than 2 years.
Almost 2 years, my lord. Because, my lord, yes, my lord. Lordship.
What is the exceptional circumstance in your case?
For want of documents, my lord, exceptional
That
case,
cannot
my lord,
be.
only for want of documents, my
Want
lord.
of document
Same
cannot
could
be
not
the
be,
exceptional circumstance.
same could not be prepared, my lord. My prayer is that, my lord, since the WS is on record, it can be accepted, my lord.
Maybe after 10 years, you come in with the WS that my petition is accompanied by the WS, so it should be accepted.
It's not that, my lord. Actually, my lord, in fact, my lord, the claimant should not be, to my humble submission, my lord, the claimant would not be prejudiced, my lord. Ultimately, my lord,
No,
interest has to be
prejudice is
borne
not
by us,
the-
my lord.
Prejudice is not the sole criteria.
Interest has to be borne by us, my lord, because otherwise, my lord, we'll have to bear the interest, my lord.
That is because of your own fault.
Yes, my
not
lord.
the fault of the other side.
That is there, my lord. Admittedly, my lord.
In which paragraph you have explained the delay?
My lord, paragraph 6, continuous, my lord, 6, 7, my lord, 8, 9, 6 to 9, my lord, and 10 as well.
Whether you have been informed about the accident immediately after the accident?
My lord,
Whether you have been informed immediately after the accident?
no, that is the case, my lord, because the otherwise it has been the duty of the police authority to inform us, my lord.
No, forget about the police authority, whether the claimant have informed you.
My lord, the notice, in fact, itself, intimation of the accident, my lord. Notice to us, notice to the MSCD case, my lord, is also is a kind of an intimation to us, my lord. Prior to that, no such intimation, my lord. We received the notice only, my lord.
When you have received the notice from the MSCT?
My lord, I have to take instruction, my lord, because the notice is not enclosed here, my lord. Only the claim petition is enclosed. I have to take instruction for that, my lord.
When the claim petition was filed?
Yes, my lord. Notice was received on 9th May 23, page number 21, my lord.
9th May 23.
23. And the order we
Page
have
number?
page number 21, my lord. Company seal is there. Page number 21.
Okay.
And the written statement,
When it was filed, when the written statement was filed,
25/6/25,
page number?
page number 41. Second paragraph, my lord.
More than 2 years.
More than 2 years, my lord. Yes, my lord.
Mhm.
Almost more than 2 years.
Okay, we'll examine the grounds.
My lord.
If found not satisfactory, then we will dismiss the same.
Lord, we are ready to, my lord,
Mm.
deposit some cost also, my lord, if lordship.
No, no, no. If we allow this time, then again you will come after 3 years. And you will submit that in case number so and so, this court has allowed the pair after 2 years.
My lord,
That cannot
on
be.
this, now it's a question of acceptance, my
Okay,
lord.
next item.
Otherwise we'll be barred from reading evidence, my lord. If
Pardon?
written statement is not accepted, my lord, would be barred from adducing evidence. my lord.
Maybe.
Family item 24.
Much obliged.
An objection submitted against the delay petition.
Mm.
The petition may be disposed.
Petition may be allowed.
Yeah, no, as disposed lordship as per the merit or subject of objection.
What is the ground for failing to file the revision petition within time?
Your Lordship, we have filed the application for a delay of 23 days. As on 3/6/2024 in filing civil revision against the impugned judgment and order dated 9/2/2024.
What is the ground?
Your Lordship, we have mentioned the reason for the delay in paragraph 2 and 3, and in similar matters, the court has already granted condonation. Your Lordship, the original CRP matter where we have filed the appeal against the order passed by the additional session judge of FDC number 2 Tinsukia, where the order was where it has set aside the order passed by the estate officer of NF Railway for the eviction of the respondent.
Third means your name, please.
P.R. Chaudhary on behalf of H. Gupta.
Learned counsel appearing on behalf of
H. Gupta.
H. Gupta, learned counsel for the applicant, and Ms. Kaur. R. Kaur, learned counsel for the respondent, opposite party. This application under chapter 5A, rule 2, within bracket cap 2 of the Gauhati High Court rule is preferred by the applicant for condonation of delay of 23 days for preferring connected civil revision petition against the judgment and order dated 9/2/2024 passed in Miss Appeal number 20 of 2023 passed by the learned additional session judge number 2 FTC Tinsukia in FTC Tinsukia. Learned counsel for the applicant submits that due to delay in obtaining certified copies and in receipt of the same, and also due to internal communication with the department, and also delayed receipt of legal opinion from the central government council, the connected civil revision petition could not be filed in time, and the same has been explained in paragraph number 2, 3, and 5 of the application. Where is paragraph number 4? And that the delay is not intentional and rather the same is circumstantial, and it's a bona fide one, and therefore it is contended to condone the delay of 23 days in preferring the connected civil revision petition. The learned counsel for the opposite party, however, submits that though no objection petition could be filed, yet the application may be disposed of on merit. But having heard the submission of learned counsel for both the parties, this court has carefully gone through the application and the documents placed on record, and also the statement and environment made in the paragraph number 2, 3, and 5. 2, 3, and 5. Then it appears that due to delay in obtaining certified copy and in receipt of the same, and also due to internal communication with the department, and also due to non-receipt of legal opinion from the central government in time, the appeal could not be, no, the connected civil revision petition could not be filed in time. And it appears that the delay of 23 days in referring the connected civil revision petition is sufficiently explained, and in that view of the matter, the same stands conduct in terms of this IA stands dispose of. In view of the order passed in the IA, now the register will proceed to register the civil revision petition and to place the same before the court as soon as practical.
Turning at 31.
Huh? Oh.
May I please, Your Lordship? Your Lordship, this matter was supposed to file the objection, Your Lordship, but the conducting counsel, Mr. R.A. Joshi, is not well, Your Lordship, and he is not attending the court. So the last chance, 1 week time may be given, Your Lordship.
1 week.
Yes, Your Lordship.
Okay. Hard miss.
P. Agarwala.
P Agora. B Agora.
P.
P. Learned counsel for the applicant and Mr.
R.A. Mazumdar.
R.M. Soduri.
R.A. Mazumdar.
Learned counsel appearing on behalf of Mr.
R.A. Chaudhary.
R.A. Soduri, learned counsel for the opposite party. Mr. So-and-so, learned counsel submits that the objection could not be filed as the conducting counsel is indisposed of. Indisposed of, and pays for granting last opportunity. Fair allowed resolution the matter after a week.
Obliged.
Turning item 32.
Paperwork was supposed to appear, however, these are legs, but I've been told that we need some more time to get the instruction, Your Lordship, as regards the vehicle.
We were newly included.
Pardon?
We were newly included as respondent number 2.
Art Mr. A. Mena, learned counsel for the applicant, and Miss
M. Kolita, Your Lordship.
M. Goleta, learned counsel for the respondent. Learned counsel appearing on behalf of Mr. D. Gogoi, learned standing counsel for the Forest Department. Ms. Goleta submits that some time may be granted to the respondent opposite party to file the objection. They are allowed recessal is the matter after a week. And considering the facts and circumstances on the record, last opportunity is given to the respondent to file their objection. In the event of failing to file the objection before next date, the court will proceed to hear and dispose of the matter without their objection.
Obliged, Your Lordship.
Items for admission. 9 and 10, coordinated.
May I plead your lordship?
Yes.
Yeah, the petitioner is paying for area salary for a period of 16/10/2015 to 14/7/2022, my lord. The case of the petitioner is that the earlier the petitioner was appointed and thereafter she is drawing her monthly salary till 2009, my lord. After 2009, the petitioner service was terminated. And thereafter, the petitioner service was regularized, my lord. That is on page 36, annexure 12, my lord.
Page
Page 36, annexure 12, my lord.
96.
May I read? In pursuance of the Honorable High Court judgment and order dated 6/2/2015, passed in writ appeal number 182/2013, a batch in the event of miscase number so-and-so, filed by the BTC and consequent upon BTC Executive Council meeting resolution number 4.1 dated 27/4/2015 and departmental meeting of Education Department resolution number 4 dated 26/6/2015, respectively, in consonance with the approval received from BTC, that is with the approval from received from BTC, so-and-so dated, and on being termination order withdrawn by the BTC by order date so-and-so 16 October 2015, Kalpana Burman, who was terminated from service, order dated third.
Madam, which page you are reading?
Yes, 36. 36, my lord.
36.
Annexure 12.
36, annexure 12. Yes.
23rd June 2009, issued from this and hereby withdrawn, and his service is regularized, reinstated as assistant teacher in Pub Nalbari Balika LP School in the scale of so-and-so and grade pay to 2,500 per month, plus other admissible allowances and admissible under existing gov rules. The regulation of the service of the individual teacher shall be subject to the following terms and conditions. The regulation order shall come into force with prospective effect, my lord. From 16/10/2015, your petitioner was reinstated and regularized, and she joined in the service. And from 2015 to 2022, my lord, but her salary was not released, my lord. On 14 July 2022, that is page 46, annexure 15, another order was issued from the Director of Education BTC. Lordship, kindly carry page 46, annexure 15, A. In exercise of power conferred upon the Director of Education BTC, Koprajar Vice Secretary BTC, so-and-so 13 September, and in pursuance approval BTC, so-and-so 14 July 2022, and Government of Assam communicated dated so-and-so 9/2/2021, the service of Kalpana Burman, assistant teacher Nobin Kori MES, who was reinstated in the service by the order dated 16/10/2015, issued from this end, is hereby regularized as assistant teacher and in posted in Satish Mukha LP School in the scale of pay 14,000 plus grade pay 600 to 6,200 and other allowances at admissible under the existing gov rules. From this
second regulation order, she received her monthly salary regularly from 22. But the respondent authority is issued two regulation order. First regulation order was 16/10/2015, that is Annexure 12, page 16, my lord. From 16/10/2015 till 14/7/2022, the salary is not paid. And from 14/7/2020, she received her monthly salary regularly till date. That is her case, my lord. That this period, she is continuously working, but salary is not paid, my lord, after regularization and reinstated in her service, my lord. So petitioner is claiming her LRE salary on that period, my lord. 16/10/2015 to 14/7/2022. And affidavit have been filed by the BTC authority and saying that earlier the first regulation order was not in a substantive post, but that was not mentioned in the first regulation order, my lord. If it is mentioned that the petitioner was regularized and reinstated in a non-substantive post, my lord, but in the second order, they are also not mentioned any that. So keeping dark the petitioner that though her service was regularized, but not in a substantive post, the C is working on the strength of the earlier order, my lord. Suddenly, the second regulation order was issued, and from that order, she received her monthly salary, my lord. So she claiming that period, my lord.
Yes.
On the last occasion, I came about time before the honorable court. I taken instruction from my client. The stand is said the earlier regularization was in lordship against a non-existent post. Lordship, in the event of the matter, lordship, the payment could not be made to them for the area part, your lordship. And subsequently, lordship and though page 36 is her lordship is not continuous, your lordship. It's in Purnolpari Balika LP school, in the school, whereas from 2022 order at page 46, it is Sati Samukha LP school. The school is different. The stand of the BTC is that earlier regularization order was against a non-existent post. In the event of the matter, payment could not be made to them. Apart from that, your lordship, government of Assam is the ultimate authority who releases fund, lordship. And my lord, may I submit one thing, your lordship, ordinate bench is already dismissed on petition the same ground. Lordship, and the writ appeal is pending. This matter may come out after the decision of the writ appeal, my lord.
But that only on the ground that the petitioner was reinstated on the non-substantive post. But that is a procedural lapses, my lord, on the part of the respondent. Procedural lapses cannot be a ground that the petitioner cannot be a ground to deny her salary for the work period. And the first regulation order, there is nowhere mentioned that they were regularized, but she was regularized in a non-existent post. They were completely kept in dark that her service was regularized, non-existent post, but approval is there, my lord. BTC authority has approved the post. As the petitioner was working after regularization of service for last 7 years, and
So what is the number of the appeal? Rate appeal?
Writ appeal 309/2025. Pending
9 of
consideration.
2025. At what stage that case is pending?
Lordship.
At what stage it is pending?
Lordship, first the delay condemnation, it was allowed in one of the matters, and thereafter probably it has become minority. Suppose it 309. 2025. Admission.
what? 26 September. Check your last notice.
Oh, no, it's not too soon. Hey, you person, so I'm on the side.
26, what? September.
Open up to 14/7 or order.
2026.
National actually.
Yes.
So, let the matter come after disposal of the writ application. Because in respect of similarly situated teachers, a coordinate bench has rejected the pair. Writ appeal is pending. Let the appeal be disposed of.
Then the lordship is to release it from partner because it may take some time. The partner matter
Pardon?
may not be permissible as per new.
They will do the needful in this regard.
For partner matter, lordship may not keep it for a long time, says further.
You go to the registry.
No, I have no previous my lord. Yes, automatically.
Heard Miss Buzur Borua, learned counsel for the petitioners. And Miss Oya, learned senior counsel standing counsel for the respondent BTC. And Mr. Sharma for the respondent number 1 and 2. During the course of deliberation, Ms. Oya has pointed out that a coordinate bench of this court in WPC number 6020 of 2017 has dismissed the pair of similarly situated teachers like the petitioners herein and against the order passed in the WPC dated 14/7/2025. One writ appeal is pending before the division bench of this court, being writ appeal number
309.
309 of 2025, and the same is yet to be disposed of. And the outcome of the said writ appeal will have some bearing upon the outcome of the present petition. And in that view of the matter, see press for listing the matter after disposal of the writ appeal. Pair allowed. Rest shall list this matter after disposal of the writ appeal number so and so so and so.
May I please, my lord?
Yes, Mr. Dotto, any instruction?
Lordship, instruction is that we have obtained certain instruction from the inspector of school, whether the Kakula Pritcha was covered under the earlier judgment of the Honorable Court, for which pension lordship under whole scheme lordship. That instruction we have received, the department is considering the matter. It will take another 10 days time to take a decision on that. This is the today.
Another 10 days time.
10 days time the department will require after 17. To take a decision whether that petitioner's case will be covered by the judgment of petitioner Honorable High Court or not. For considering this case for all pension scheme lordship. Otherwise, the one relief has been already
Granted.
Granted. That's remaining the pension part only.
That is the main part, my lord, regarding pension.
Then grant us the early 10 days time. After 17.
After 7 days.
17.
17.
17. 17 lordship.
Okay, wait for 17.
My lord.
We'll list the matter after 17.
My lord, but I
wait for some time. Heard Mr. Alam, learned counsel for the petitioner, and Mr. Dotto for the learned standing counsel for the respondent in elementary education department. Mr. Dotto submits that the matter is being examined and it will require another 10 days time to take a decision by the respondent authority. And a price for listing the matter after 17. We are allowed recess and list the matter on 23rd.
Let it be, my lord, 25th, my lord.
25th. Okay.
Obliged.
For the AZ. Okay. Mr. P. Sharma, learned counsel, appearing on behalf of Mr. B. Sharma. MP Sharma for B. Sharma, standing counsel for the AZ.
Obliged.
Item 12.
May I please, your notice, kindly matter may pass over for time being, Mr. Ege Gupta is under report.
But in this case, my lord, I have filed an affidavit today, my lord, for seeking leave of the court
Leave of the court?
to withdraw my wakalatnama. My lord, I have already sent the notice to my client, my lord. I have also informed him about telephone.
Heard, Miss?
We knew on behalf of K. Agarwal.
Learned counsel appearing on behalf of Mr. K. Agarwal, learned counsel for the petitioner, and Mr. Gupta for the respondent.
Respondent number 8, my lord.
Respondent number 8. None appears for rest of the respondent. Mr. Gupta submits that he has already filed an application for withdrawal his wakalatnama. When did you file?
Today in the morning, I have called the affidavit.
Okay. Affidavit or application?
Affidavit, my lord.
Submits that he has already filed one affidavit for allowing him to withdraw the wakalatnama on behalf of, no, for the respondent number 8. And he has already sent notice to the respondent number 8. And he has also enclosed the copy of the letter written to the respondent number 8 as annexure number 1. Of the affidavit. Accordingly, taking note of the submission of Mr. Gupta and also considering his affidavit, he is allowed to withdraw his wakalatnama. Which he has filed for the respondent number 8. Accordingly, it is provided that Resti shall issue notice to the respondent number 8. List the matter after 4 weeks.
Okay.
Item 13.
Different matter to be passed over for time.
I'm being.
My lord, fix another day, my lord. Well,
Heard Mr. Atia, learned counsel for the petitioner, and Mr.
H for RLA.
is Setri, learned counsel appearing for RLA. Learned counsel for the respondent. So Setri submits that conducting counsel is in legs in another court and press for listing the, no, press for taking up the matter after some time. However, Mr. Atia, learned counsel for the petitioner, submits that the matter may be fixed on some other date fair allowed, raises or list the matter on
April. 6 April.
18.
Public. Item 14.
Yeah, Peter Lordship. Time for response number 1, we actually played for adjournment today.
My lord, from July 2025, 7 days for objection, and then objection file again rejoin that they have taken time, my lord. Only simple issue is that amendment.
Recently, you have got a brief, Lordship, so.
Yes, my lord. Simple issue is amendment. They are rejected. We have came here because they are necessary party and amendment is required. That is merit will decide in this lower court, my lord. So that simple issue, my lord. Developers says that 30% is petitioner, 70%. But when is given, ground floor is excluded. Then in the pendency of this title suit, some are given allotment in ground floor. They don't want to make them party. And whether we are entitled to ground floor or not, that will be decided in trial court. That is it. Lord, please.
But if another date will be given.
or Mr. Borwa, learned counsel for the petitioner, and Mr.
P. Borwa on behalf of P. Bhattacharya on behalf of A. Borwa Lordship. He will be filing the
learned counsel for
NOC Lordship.
Learned counsel for the respondent number
1 Lordship.
Respondent number 1. Mr. Padgiri for
Respondent number 3.
respondent number 3.
I am for respondent number 2.
Mr. Halder for respondent number 2. The learned counsel for the respondent number 1. Price for granting some more time to file objection. Pair allowed for the last time. Pair allowed for the last time. Resistal is the matter.
There may be given. The issue is not.
Resistal is the matter on 13.
Yes,
13 March. 13th of March. It is being clarified that no further chance will be granted to the respondent number 1 to file objection.
Bit longer date.
Pardon?
Bit longer date, Lordship.
No. 23 meter.
Item number 15 and 16.
May I please, Your Lordship? My Lord, I am appearing in respect of item number 16, Your Lordship. In item number 16, service report is not completed, Your Lordship. And as per office note, my Lord, as per office note 2/3/2016, service in respect of 2 and 3 are awaited, Lordship.
Oh, why both the matters tagged together?
Lord, I do not know, Your Lordship. No, perhaps opposite party prayed for.
Pardon? Okay. Heard Mr. A. Rahman.
My Lord.
Learned counsel for the petitioner. And Mr. Kayum for respondent number?
1, 2, 3 in item number 15.
No, in item number 16.
For respondent number A, 1B and 1C.
Mr. Sohan for respondent number 2, 1A or 2A? 1A, 1B and 1C.
Yes.
And okay. Office note dated 2/3/2026 indicates that service report has not been received in respect of respondent number 2A, 2Z and 3A to 3E.
2A, when I that issue of the item number 50. It can be the correct instruction. 2A. Hussein. He is the petitioner in item number 15.
No, he will take fresh step upon them.
I have taken fresh step. Today, fresh steps have been taken, Your Lordship. In
The
terms of-
learned counsel for the petitioner submits that he will take fresh step upon the aforementioned respondent.
And not already taken as per the last order.
Where?
Your Lord. As per last order, my lord. Lordship may kindly peruse the last order. 4/2/26, Your Lordship.
Or
On the last occasion, I was allowed to take fresh step, Your Lordship. Accordingly, steps have been taken.
okay, receipt shall raise the matter after 2 weeks awaiting service report upon the aforementioned respondent. Interim order, if any, shall continue.
No.
Release the matter after 2 weeks.
Bless you.
In 15.
May I please, Your Lordship? In 15, Lordship, service completed, Lordship.
Service completed.
Service completed.
Okay, then we will list the matter for admission.
Admission.
But today it is a list for list.
Item number 16.
Today it is listed for admission, Lordship, along with item 16.
Pardon?
Today is listed for admission, Lordship.
Admission, yes.
Item number 15 and 16, my lord. My lord, the 15 is filed by the legal head of the alia, my lord, doctor. And item number 16 filed by the third person against the execution order, to stop the execution. So, my lord, both the cases kept with them. In item number 15, service is complete. I am preparing all the respondents. And item number 16, my lord, data is appearing.
No, in item number 16, service is yet to be completed.
Yes, sir.
So the counsel for the petitioner will take fresh step. No, sorry. We await service report upon them. And in this matter, service completed.
Yes, sir.
So today the matter is listed under the column admission hearing. You argue the matter?
My lord, since my lord, in this case, my lord, entry order passed as per my lord, to order passed in item number 16. So, my lord, both the matters may be taken, my lord.
No, in that matter, service is yet to be completed. Can we hear the matter?
Lordship, I have no problem. I am ready. I am ready to.
Since my lord, there is an interim order in item number 16, and that my interim order is going to be in my case.
That
So,
interim order? That interim order?
Is my lord also passing my lord to item number 15.
No, is there any bar in hearing the matter singly?
I am no objection.
Then?
My lord, then I'm ready. I'm ready, my lord.
Interim order is not an issue, Lordship.
In this case, no interim order was passed.
In this case also.
Right?
In this case
As
also.
part of the interim order passed in the item number 16, the interim order was passed.
Sure, I am the legal heir of the judgment date, Lordship. Page 26.
There is already one order of this court for detachment of that order, that CRP.
Yes,
37.
yes. These are period below. As per this. নাই hearing তো দেরি কোনো এমনি থাকলে ভালো কিছু নেই।
So both the civil revision petition are against the same title execution case.
Same case.
So stay is granted in CRP number 37.
Yes. And that is the order is continuing in item number 15.
So I think it is better to hear both the matter together.
That is why.
Because even if we pass any order in this civil revision petition,
I think that will be better. I
the
think.
stay will be operating
Lordship,
in that
Lordship.
matter.
It will be better to heart together, Lordship.
Part Mr. A. Islam, Learned Counsel for the petitioner, Mr. Kayum, Learned Counsel for the respondent number 123. 123. So this matter is ready for admission hearing yet. It appears that against the same execution, against the order passed in the same execution proceeding, another CRP IO number 37 of 2023 is pending. And in the
On the CRP, CRP.
but here it is mentioned as CRP IO.
In CRP, are you in?
CRP. Okay, CRP IO. No, sorry, CRP 37 of 2023 is pending before this court, wherein one state order is operating and the said CRP is not ready for admission hearing as services yet to be completed, and it is submitted at the bar that in the interest of justice, the CRP IO 525 and 2024 and CRP 37 of 2023 may be heard together. Accordingly, it is provided that Rescission list both this matter together after 2 weeks. After 2 weeks.
Also, in the meantime, the interim passed in this matter.
Okay, interim order passed in the CRP 37 of 2023 shall continue.
Obliged.
Thanks for hearing under the 41 number 17.
May I please your lordship, can it be taken at two your lordships?
Pardon?
At two lordship.
Why?
If my subordinate is gone somewhere, I am to get his assistance, lordship.
But we have not much cases today.
Lordship.
Next.
May I please, your lordship. An appeal under section 100 of the Code of Civil Procedure, the judgment and decree dated 35/2025, lordship, passed by the learned civil judge senior division Gauhati, title appeal number 2 of 2025.
were dismissing the said title appeal by not interfering with the judgment and decree dated 31/12/2024 and 7/1/2025 passed by the Learned Civil Judge, Junior Division 2, with title suit number 24 of 2017. Lord. The respondent as a plaintiff filed a title suit before the Learned Civil Judge, Junior Division number 2, Gulagat for declaration of the right title interest of the plaintiff over the suit land and for delivery of khas possession of the suit land in favor of the plaintiff after evicting the defendant from the suit land, demolishing the structure made by the defendant illegally on the suit land. What happened was that appellate court, due to wrong calculation, came to conclusion that there was no question of devolution of any land of suit dark number 429 to the successor of late Satyanarayan Sahu, although a plot of land measuring 10 lessa is still there. Also. The total land measuring 1 bigha 11 lessa lordship. The government equate 1 kotha 4 lessa, sold out 1 kotha 7 lessa to Naresh Agarwala and Suresh Agarwala, and 2 kotha 10 lessa to the respondent. And after deducting all above land, there is a plot of land 10 lessa remain which is missing in the judgment lordship. After deducting government equate land sold to the Agarwala brothers and Schedule A land, a plot of land 10 lessa remain in the share of the appellant, which is missing in the trial court and the appellate court too. On earlier occasion, lordship, I have made some submission and already
How the suit is barred by section 6? Six relates to pecuniary jurisdiction.
Yes, Lordship.
It is a title suit.
Yes, Lordship.
Where is the question of pecuniary jurisdiction?
Actually, Lordship,
Huh?
they have filed entire land, Lordship.
Hmm?
They have filed entire land, Lordship. Without partition, Lordship.
So the plaintiff was not cross-examined by the defendant.
Defendant, Lordship.
Why?
Well, Lordship, actually, Lordship, the advocate, engaged advocate, earlier engaged advocate has not informed the present appellant, Lordship. And he have no knowledge that he was not cross-examined by the appellant.
No, whether it was a expertise decree.
Not expertise, but
Then
Lordship, in page 18, Lordship, the judgment,
is 80.
18, Lordship,
1-8.
186.
Yes.
From the father of the defendant number 1 and 2, and the father-in-law of the defendant number 3, namely Satyanarayana Sahu, son of the Ramdas Sahu, in presence of the witness exhibit number 2, was the Jamamati, where the name of the plaintiff is in the respect of 2 Kotha 10 lessa of land in Patta number 5, Dak number 2429. By dint of the purchase of the from Satyanarayana Sahu, since deceased, he had also attached the revenue payment received in receipt of PP number 5, Dak number 429 for the year 2014 to 15, 16 to 17, 17. On careful perusal of the evidence on record, it has been that seen that sale deed was duly registered.
Whether the cross-examination was barred by the court by order dated 17/12/2021.
Yes.
Where is that order?
Lordship, this order not annexed, Lordship, and
Is it with you?
no, Lordship.
So the substantial question of law suggested by you are these are not question of law but of question of fact. Number 1, that is not applicable here. Number 2, cross-examination is barred by the learned trial court.
Yes, Lordship.
Number 3, proper calculation, that cannot be a substantial question of law. Number 4, same calculation.
Lordship, as per direction of the earlier court, Lordship, I have made some another substantial question, Lordship.
You file it by way of an additional affidavit,
Yes, Lordship.
by way of an affidavit. But here also, these questions have not been properly formulated. Heard Mr. Z.Z. Gogoi, learned counsel for the appellant. Mr. Gogoi submits that person to order of this court dated 7/2026. He has formulated some other substantial question of law. And accordingly, it is provided that he shall file the same by way of an additional affidavit. Lays the matter on. Correct. It is further provided that Mr. Gogoi, learned counsel for the appellant, shall also produce before this court the order of the trial court dated 17/12/2021, by which cross-examination of the PW1 was barred by the learned trial court. Listen.
Lord, in this case, my lord, this is a case of reversal, my lord. The trial court had allowed the case of the plaintiff. That is, the judgment is at page 62 of the appeal. At page 67, relevant, my lord. Issue relates to as regards Schedule B of the land. $67, my lord. $67, sorry, last paragraph, my lord. It is pertinent to mention that in the present case, the defendant have not directly disputed the title of the plaintiff over the Schedule A land. In their written statement and in evidence of an affidavit of DW1, Sri Pradip Das has clearly mentioned that the predecessor in interest of the plaintiff, Sri Rakhal Chandra Malakar, purchased 8 letters of land by registered sale deed number so and so. The land is covered by DAG number so and so. The only dispute with respect to the contention of the defendants that there is no suit part as asserted by the plaintiff and mentioned in Schedule B of the plain between the land of the plaintiff and the defendant. Yes, my lord.
Have you mentioned the substantial question?
Yes, my lord. That is at page 25, my lord.
25.
Issue, my lord, I am harping upon, my lord, number 3, my lord.
25.
25, 26.
No, you say subsection 3 to section 100 provides that it should be mentioned in the memo of appeal. You have not mentioned the substantial question of law in the memo of appeal.
Well, it's a part of the appeal. It's a part of the appeal. I'll insert it. I will incorporate it otherwise.
No, you see the section.
Number 3, in an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal, my lord.
You have not mentioned it.
It's part, my lord. I will incorporate it.
Heard Mr. Khan, learned counsel for the appellant. A perusal of the memo of appeal indicates that substantial question of law has not been mentioned in the memo of appeal as required by subsection 3 to section 100 of the Code of Civil Procedure. As account submits that he may be granted some time to file amended memo of appeal incorporating the substantial question of law. Where allowed, recess unless the matter after a week,
After we, next Friday, my lord.
Friday.
Friday. 30. Much of it.
Around 36 for movement.
Wait, sir. My lord, yesterday's matter, my lord, regarding my lord non-payment.
Letter to the home department. So now matter is pending before the home department for sanctioning the account.
So, madam, can you obtain instruction from the home department then?
Yes, sir.
Or is there any counsel for the home department? No,
We are.
you can.
Yes, Lord.
You can. But the problem is that there is already an order of the executing court
Yes, Lord.
for personal appearance of the judgment debtor.
Yes.
Where is that order?
My lord, in the last page, my lord, at page number 79.
79.
79.
Page number 79.
And operative portion starts from 87.
87.
For settlement of defeat allowed.
Yes.
Personal and
Continue.
Some process to get sanction process.
Where it is directed to appear him before the.
My lord, only all the previous orders, my lord.
Huh?
That prior orders, my lord, lordship will kindly see. It starts from page number, my lord, 63. 63, there is one order, and lordship will kindly see 56. 15, 12, 20, 25 order.
There's number?
56, man.
experience and necessary orders for security. Not a personal experience.
So thereafter, my lord, on 9/1/2026, again a direction was passed, my lord, giving last chance to the JD to appear at page number 63.
This order dated 28/5/2025 is at page number
28. But that it starts from page number 45. 45. And relevant portion is at page number 48, last paragraph, underline portion. To appear in person along with an affidavit stating the particulars of assets.
Heard Mr. S. Das, learned counsel for the petitioner, and also heard Ms. D.D. Burman, learned additional senior government advocate. It is to be noted here that by order dated 5/3/2025, this court was pleased to request Ms. D.D. Burman, learned additional senior government advocate, to obtain the present status of the letter dated 7/1/2026 and 10/2/2026, written by the judgment debtor to the Assistant Inspector General of Police, Administration, Assam, Gauhati. And pursuant to the said order, pursuant to the request, Ms. D.D. Burman, learned additional senior government advocate, has obtained a written instruction and apprised this court that the Assistant Inspector General of Police Administration has received the letter of the judgment debtor dated 7/1/2026 and 10/2/2026, and thereafter he has sent a reminder to the government for financial sanction, and the same is still awaited. And in that view of the matter, Ms. Beaumont is further requested to obtain the status of the said letters and also the letter of the Assistant Inspector General of Police dated 26/11/2025, by which the government was requested for consideration of the sanction of the decretal amount, that is rupees 5,92,937 rupees. 47 rupees. Mr. Das submits that. Mr. Das, learned counsel for the petitioner, however, submits that by impugn order dated 26/5/2026, the learned executing court has directed the judgment debtor, who is the senior superintendent of police, Hailakandi. Now, who is the
Senior
superintendent of police, Hailakandi, to appear in person along with affidavit stating the particulars of assets of the judgment debtor, which could be attached for realization of the decretal amount. Since upon the letter dated 7/1/2026 and 10/2/2026, and also in respect of the earlier letters, the Assistant Inspector General of Police has already already communicated with the government. Communicated with the government for granting financial sanction. Financial sanction. Financial sanction, and the matter is pending for consideration for financial sanction with the government. The personal appearance of the judgment debtor and filing of affidavit indicating the particulars of assets and assets of the judgment debtor may be postponed till 13th of or short date.
Okay. Or Lordship, there is some time maybe get that Lordship. After we move our Lordship, that it for processing it will be time Lordship or sanctioning the government Lordship.
Okay. Before Behu,
Before
till 6th of April. Till 6th of April.
Yes.
6th of April. And it is further provided that the petitioner herein shall file an application to that effect, enclosing the copy of the order of this court before the learned executing court, and on such petition being filed, the learned executing court shall extend the date till 6th of April. You obtain a copy of this order and file an application before the executing court.
May I pray for copy of this order? Lord?
Yes. A copy of this order be furnished to Ms. Borman to take follow-up action. Any other method?
Highly obliged.
6 of April.
37.
May I please, Your Lordship? Here in this case, Lordship, what has happened that the petitioners had filed an application for framing additional issues that has been rejected by the learned trial court, Lordship. It is at page number 32. What has happened here in this Lordship, this prior to that, the petitioners had approached before this honorable court. And this honorable court had given a direction to the petitioners to raise the issue before the competent civil court. If Your Lordship kindly see page number 2, we are 23 annex 2, Lordship. There is a direction of this honorable court. Page number 23, Lordship. The second paragraph, the dispute raised by the petitioners is with respect to an order bearing number such and such dated Silchar 1970 September 2009, passed by the respondent number 3. On perusal of the said order and the dispute involved is apparent from the said order, the same requires evidence in order to decide the dispute between the parties. Already the parties to this petition had raised dispute in the civil court, and the petitioner also participated by filing detailed statement. In such a situation, the issue involved in the present petition may be raised in the civil court, wherein the suit between the parties is pending. Under such circumstances, this court hereby disposes the writ petition. So there is a direction of this honorable court, Lordship, and accordingly an application has been filed. It is at page number 24 for framing additional issues. The issue is only with regard
What
to.
is the impugn order?
Yes, Lordship. Impugn order is the last page, Lordship, page number 32. The defendant has filed a petition bearing number such and such to frame an additional issue, whether the order number dated such and such by the General Joint Register of Cooperative Society was legal and proper, and the said order needs to be set aside. On perusal of the case record, particularly the counterclaim filed by the defendant, it appears the defendant have not paid for setting aside in their counterclaim. Moreover, although the Honorable Gauhati High Court had passed an order stating that they may raise the issue in the trial court in the year 2017, but they did not raise the issue for the last 8 years, as the issue does not appear to be vital, and as the defendant had not raised the same till the argument's day, petition bearing number such and such has been rejected. But this is not the provision. Order 14 Rule 5 is very clear, Lordship. Even before the decree is passed, the court can frame additional issues. and also strike out
No,
the
you
issues.
say if it is not in your counterclaim,
Yes, Lordship.
why the court should frame it?
Lordship, the counterclaim, the prayer is not there. Although the
Then?
prayer is not there, but the fact is already there that this particular order
No,
is
no,
known as.
issues are framed
Yes.
only on the basis of pleadings of the party.
Exactly. The pleading is there, Lordship. In the
Ah.
pleading, it has been mentioned, but the court can mold the relief also, Lordship. Since I have pleaded the facts, and that is the reason why, Lordship, this honorable court, while disposing of the writ petition, take note of this particular aspect of the matter, even the written statement, and accordingly passed an order to raise the issue before the competent civil court.
Where is that order?
Yes, Lordship, just now I have just shown that particular order, annexed at 2, page number 23. Page 23, Lordship. May I read, Lordship? Page 23, the second paragraph. The dispute raised by the petitioner is with respect to an order bearing number such and such dated Silchar 19 September 2009 passed by the respondent number 3. On perusal of the said order and the dispute involved as apparent from the said order, the same requires evidence in order to decide the dispute between the parties. Already the parties to this petition had raised dispute in the civil court, and the petitioner also participated by filing the written statement. In such a situation, the issue involved in the present writ petition may be raised in the civil court wherein the suit between the parties is pending. So there is a clear direction of this honorable court motion. And there is nothing for time barred that I have not raised the issue at the very early stage. Because order.
Maybe you can raise the issue in a proper manner.
Exactly, Lordship. That is the reason why, Lordship, I filed the application. But for framing
This
edition.
order is updated. Who is that? It was passed.
Lordship, it is there in the petition. It was passed on 5/5/2017, Lordship. 5/5/2017.
2017.
Yes, Lordship. We have made a mention with regard to the fact in our petition also, Lordship.
Then when did you file the application before the?
This was filed, Lordship, on this one on 10th of December 2025.
This order was passed on.
This one was
passed by this court on
5/5/2017, Lordship.
5/5/2017. And when you have filed the application?
That was
before
on
the
December 2025, Lordship.
December
2025.
December 2025. Okay.
Concerned counsel, Lordship, who was dealing with the matter.
So you tell me why you slept over the
I'm just narrating
8 years?
Yes, Lordship, I'm narrating the fact. The concerned counsel who was dealing with the matter, he has died. And he was suffering from illness for a long period of time. I have narrated the entire aspect of the matter in page
No,
25.
maybe,
Lordship.
but
The fault on the part of the council, Lordship, the parties should not suffer.
no.
And when there is a specific direction of this honorable court, the other side is not going to be prejudiced in any manner, Lordship.
No.
Because it's only the adjudication of the issue, because it is there in the pleaded case of the petitioner also, Lordship.
No. Once the issue is framed,
Yes, Lordship.
you will file another application.
No, Lordship, this is
So as to adduce evidence.
No, we'll not file. We have only paid for framing additional issue. We have not paid anything else, Lordship. These additional issue, court can take note of that and accordingly pass the judgment.
You see,
Yes, Lordship.
uh,
Court can pass an order giving a specific restriction to the defendant to stick to that particular issue and no evidence.
The
will be
question
left.
is that this issue
Yes.
cannot be framed because it is not in your pleadings.
No, Lordship, it is there in our pleadings, Lordship.
You saw?
And
So-
that is the reason why, Lordship.
It is also not there in the counterclaim.
No, Lordship, it was there in our counterclaim. And that is the reason why, Lordship, in the written
You
statement.
saw the counterclaim?
I'm not annexed it because, Lordship, at that point of time, I was not having that document. The document which I'm having is not legible. That's why I could not attach, because tomorrow is the date for argument, Lordship.
Maybe.
And that is
But
the
it
reason
will
why
not
I filed it.
issue any stay order.
Because on the last occasion, Lordship, this honorable court has passed an order on perusal of the written statement. Because written statement, it has been specifically mentioned, the issue has been raised in the written statement. If your Lordship kindly peruse the order again, it is there in page number 23. The petitioner also participated in filing the written statement. In such a situation, the issue involved in the present writ petition may be raised in the civil court. So it has been very specifically and clearly
That's all
specified.
right. Thereafter, you could have filed an additional written
That is the
statement.
fault on the part of the council, Lordship. The
No.
client should not suffer, Lordship, because they are not going to be prejudiced in any manner. The issue is adjudicated. Because this particular aspect of the matter is the pleaded case of the
So
petition.
the counterclaim and pleading, so where you have mentioned it?
Then Lordship, can it be taken away too? Having the soft copy, I will place this, download the same and I'll place it before this one. So I downloaded and this print out of the written statement, Lordship. This is the flag mark, type flag mark. This is the counterclaim, Lordship. In the counterclaim at page number 17. From middle portion, it has been mentioned. Under such circumstances, the answering defendant number 1 was surprised to receive the order dated 19/9/2009 passed by the defendant number 1. 3. By the said order 19/9/2009, the defendant number 3 moves arbitrarily the relevant resolution of the defendant number 8 society, and that without granting any opportunity hearing to the defendant number 1 by committing breach of the principles of fairly and natural justice. We have taken the specific plea on our counterclaim also, Lordship.
What are the pairs in your counterclaim?
Counterclaim for our declaration over the right title interest. It is there in page number 19, Lordship.
Page number?
Page number 19.
19.
Yes. Decree declaring the absolute ownership right, title interest of the defendant number 1, 2, 3 over the properties described in schedule below. Because this particular order is substantially affecting the right title interest of the plaintiff over the land. So if the order is declared, decreed with regard to the right title interest of the plaintiff, Lordship, the
So
counterclaim.
where is the pair for setting aside that impugn
No,
letter?
Lordship, this declaration with regard to my ownership right over the property, it's going to set aside other way around, Lordship, this order of the Zonal Joint Register, Lordship. Joint Register by the order dated 19/9/2009 came to a finding that the agreement which was executed between the predecessor of the present counterclaimants of the petitioners and the predecessor of the plaintiff is non-est or is not legally sustainable. But this honorable court, while we approach this honorable court in the writ petition, it has been mentioned that this particular issue can be taken up before the learned trial court. Now, if the decree is being passed with regard to declaring the right title interest of the plaintiff, then this particular order would go. Because if the order is there, then this declaration is not there. But the declaration is there, then obviously this order is not sustainable in the eye of law, Lordship. Because when the agreement is there, agreement is sufficient to demonstrate the right title interest over the particular property, Lordship. And that particular agreement was duly exhibited before the learned trial court, Lordship.
No, there should have been one pair in the counterclaim for cancellation of the said order.
Specifically incorporated, but the other way around, Lordship, this particular order, this prayer with regard to the decree for declaration cannot be given without taking note of the particular order of the Zonal Joint Register. Because this order is substantially affecting and directly affecting the right title interest of the counterclaimants of the petitioner over the property, Lordship. And that is the reason why this the additional issue, the prayer was made for framing the additional issue, Lordship. We are not pressing for any other relief, Lordship. We are just pressing for this particular issue to be framed and accordingly it should be adjudicated. That is the simple prayer, Lordship. And for the substantial justice, Lordship, that can be taken into account. Because order 14 rule 5
has to be done to both the parties, not only to you.
Exactly, Lordship. The order 14 rule 5
While the pair is not there in the counterclaim, why the court below shall
no,
frame
Lordship,
any
this
issue
particular prayer with regard to declaration, because if the declaration is to be granted by the honorable court, then with regard to that aspect of the matter, they have to take note of the order passed by the Zonal Joint Register. Because the plaintiff is harping upon that order. Let me be saying that this order has been passed, so this particular declaration cannot be given. So the declaration is to be given on the basis of the.
Mr. Chaudhary, you see, this is not a writ petition. This is a review petition. We are only testing the legality, propriety, and correctness of the order.
Exactly, Lordship. Order 14 rule 5 is very clear, Lordship. It can be done. And
like the writ petition, we cannot grant any relief here by molding any relief.
Now, the finding of the learned trial court, Lordship, with regard to the delay. Delay is not there, Lordship, because order 14 rule 5 is very specific. At any point of time that can be raised, Lordship. And in the counterclaim, whether it has been taken or not, pleaded fact is there. In the pleading, it is there, and court can very well mold the
No,
relief
no.
also, Lordship.
Here you have mentioned that one writ petition was filed
Yes, Lordship. And that order
and
just now,
notice was
Lordship,
issued.
yes, I have shown that order, Lordship. At that point of time, notice was issued. And
Mm.
subsequently, during pendency of this title suit, Lordship, this writ petition was disposed of, giving liberty to the present petitioners or the defendants to raise the issue. And accordingly, it has been taken.
And thereafter, you could have filed a additional written statement or counterclaim.
No, that was not done, Lordship, because the fact, this particular prayer
No.
with regard to
After
declaration
7
of,
years.
Lordship,
After 7 years.
7 years is there, Lordship. That explanation has also been given in the petition. But more to that, Lordship, there is no limitation prescribed in Order 14, Rule 5, Lordship. And this defendant is not going to be prejudiced in any manner, Lordship, because the addition of this suit-
Why prejudice will not be caused?
because this, they are
When the
also,
title suit was instituted in the year 2010,
yes, Lordship,
15 years already elapsed,
exactly.
and you were submitting that no prejudice will be caused.
No, Lordship, but the fact is that, Lordship, this particular issue which is to be framed, this will for the advancement of
Mr.
justice.
Chaudhary,
this will-
be logical.
Yes, Lordship. Because when I made a prayer for declaration of my right title interest, obviously the court comes to a finding that yes, on the basis of that particular agreement, you are entitled or you are legally in a position to take possession of that particular property or in possession of that particular property. Then this order of the journal generation would go. Not directly, but indirectly, this will going to affect the order of the journal register. And that is the reason why, Lordship, this application has been filed to incorporate an additional issue. Because the plaintiff is not going to be prejudiced in any way, because the plaintiff is also harping on that particular journal joint register order. They are saying since the order has been passed, so on the basis of that order, we are the rightful owner of the property. It's not the fact, Lordship, because the predecessor of the present petitioners or the predecessor of the plaintiff had executed one agreement, Lordship. This is our case. On the strength of that agreement, the predecessor of the petitioners came into possession of the suit premises and is in possession of the premises for last 15, 20 years, Lordship. We are in possession of the premises, Lordship. So since we are in possession of the premises, the journal register, whatever order has been passed, this particular order has not taken into account the factual aspect of the matter, Lordship. In the counterclaim, Lordship, prior to that, referring to that order of the journal joint register, it has been mentioned, if your Lordship kindly take a note of the pleadings on the party of the petitioners, that thereafter the plaintiff submitted an appeal before the defendant number 3.
Okay, we'll see and pass the order. Yes, next item.
17.
May I please, your lordship, I am highly. Lordship, I am taking your lordship to page number 28 of the trial court judgment, your lordship. May I read, your lordship? Lordship, the case of the plaintiff as stated in the plaint is that the plaintiff is a recorded patadar having right title and interest over the land measuring 1 bigha 2 kata 10 lita covered by dag number so and so, periodic pata number so and so, under Moja so and so, district Charadu. It is stated that the father of the plaintiff, namely Rajani Bothakur, was an employee of Mathuraputty state, where he was allotted a company's quarter. The entire family of Rajani Bothakur, which include his 4 sons, resided in the quarter. The eldest son of Rajani Bothakur, the present respondent, the Sanjeev Bothakur, stated to do the contextual work in ASCB Maibela since 1980. At that time, the plaintiff had occupied more or less land, less 1.5 bigha of land, dag number 46, at 101 grant by cleaning jungle and build a L pattern Assam type house thereon in the year 81-82. In the year 1984, the father of plaintiff retired from his service, and after his retirement, his family members started to reside in the said house, which was built by the plaintiff at 101 number Grant, as company's quarter had to be vacated on the retirement. The El Cotton Assam type house is standing upon an area of 1 katha 10 lesa out of 1 bigha 2 katha 10 lesa, bearing patta number 76, dag number 132. So, the plaintiff father Rajani Bhattakur expired in the year 1995. In the year 2002, the second son of Rajani Bhattakur, namely Rajiv Bhattakur, the present appellant before your lordship, the defendant left the plaintiff house along with newly married wife and started to live in a rented house. The Revenue Department of Govt of Assam started to collect land revenue, Toji Khazna.
No, Mr. Gupta, you come to the substantial question of law.
Lordship, that is in my amended memorandum of appeal, your lordship. In page number 11, lordship. Page number 11, lordship. Substantial question of law. Number 1, whether the learned court below have committed error by not appreciating the law of inheritance while deciding the right, title and interest of the suit premises and land in respect of joint undivided property originally belongs to deceased father. Number 2, your lordship, whether court below disregarded mandatory legal provisions in respect of allotment of land in question in favor of the respondent, which was granted without following due process of law. Whether
what are the legal provision for allotment of land in question?
Lordship, that's my submission before your lordship there. He was not in possession prior to the allotment of the land. He got allotment for another plot of land in 2008, lordship, 1 bigha of land nearby. And he shifted from there, from original this suit premises, he shifted to that place, your
Mr. Dasgupta,
lordship.
You tell me what are the mandatory legal provision which the learned courts below have disregarded?
Lordship.
What are those?
Lordship, Assam Land Revenue Regulation, lordship, 40 and 41, lordship.
Also land policy.
Assam Land Revenue Regulation, lordship.
Okay. এটা কাম কৰে এটা
41. 41 is age.
আমাৰ এটা পাৰ্টনাৰ বুলি কৈছে কাৰণ আমি সাবস্টেন্সিয়েলি জানিছো তো
Record of right, lordship. May I go through, lordship? Jamabundi based on Chita, actual possession on relevant. Section
regulation?
Regulation
40 and 41, lordship.
40 and 41.
Lordship.
Yes.
I am reading now 40, lordship. Record of rights. The settlement officer shall frame for each state a record of right in prescribed manner. The record of right is the Jamabandi on the Chita and the field map. Record of right. Jamabandi based on Chita, actual possession relevant. Section 40 of the Assam Land and Revenue Regulation provides for record of rights. The settlement officer has to frame for such state a record of right in the prescribed manner. The note appended to the section shows that the record of right in Jamabandi based on Chita and the field map entry in the record of right has to be founded on the basis of equal and actual possession. At the time of settlement of Jamabandi is prepared which record name of Patadar on the basis of possession. Lordship, admittedly, he was not in possession. My submission before your Lordship, Rajani Borthakur, who acquired that plot of land in 1970, Lordship, father of the plaintiff and appellant, both, Lordship. He acquired the land in 1970, and since then he was paying the Toji revenue, Lordship. Rajani Borthakur. Entire family shifted to this El Patan Assam type house, Lordship, constructed by the father Rajani Borthakur. Lordship, he stated in his plain that he has constructed house in 81, 82, Lordship. But in his cross-examination, he categorically stated that he was a student till 84, Lordship, 1984. So how it is possible to construct by him, Lordship?
No,
Moreover, your Lordship,
these are all question of facts. So
question of
sitting in
fact, it's
second
derived
appeal, we
question.
should not decide the issues of facts.
Lordship, my submission before your Lordship that he was not in possession. He already admitted he shifted to another plot which was allotted to him, 1 bigger plot of land, Lordship. He already stated categorically. He shifted because of ailing brother and mother. He shifted his family to another plot of land nearby, which was allotted to him, 1 bigger of land, Lordship. Possession is mandatory, your Lordship. He was not in possession at that relevant period of time. The appellant's mother and ailing brother, they were in possession. They even not get any notices from the authority. They are eligible to get notices, Lordship. Until and unless they are being notified, how they can know that, Lordship, someone is going to get the allotment of the land which they are possessing. They are in long possession, uninterrupted possession since the day of their father. And he admittedly he said that, Lordship, he has shifted to another plot of land which was allotted to him. And to a single person, 2 plotted can be allotted, Lordship, for whom state. It is not policy of the land regulation, Lordship. He got allotment for another land in the year 2008, and he left for that plot of land constructing his own house.
And also Assam Land Policy 1989, 14.4.
Lordship, Assam Land Policy 1989, 14.4, Lordship. What is that? That book is not with me, Lordship. In spite of searching, I could not find out.
Settlement of the government land, well, patta land. Actual position. And landless, it should be landless. Should be landless.
Behind our back, Lordship, that allotment was done. We were not in, we were totally dark. The mother was alive that time. Mother expired in the 2013, and allotment letter, annual patta granted 2012, and 2000 periodic patta granted in 2013, Lordship. And prior to that, he got allotment for another land, 1 bigger, in the year 2008, Lordship.
Should be landless for getting government land. Should be landless. Should be landless. But section 14.
And he should be landless, Lordship. He is having 1 plot of land, 1 bigger, Lordship. And now he has got the allotment totally fraudulently. He has got this, Lordship. Behind our back, Lordship, we were not getting any notice. No due process of law was followed, Lordship, in the case. That question we raised before the trial court as well as first appellate court, Lordship. We have submitted, exhibited so many documents. Electricity bill, land revenue receipt, everything, Lordship. Till today, we are paying the electricity bill in the name of my late father, Rajani Bhattacharya, Lordship. Till today, Lordship. Our documents were totally rejected, Lordship. Not considered. They have taken one side of the coin, Lordship, not other side. They have not considered our case, Lordship. It's perverse, Lordship. It's a fit case, Lordship. Lordship, maybe please. He is a retired teacher having his unmarried daughter and wife, Lordship. He is residing since his days of his father, Lordship. They have left the parental house.
We will see and pass the order. Heard Mr. Dasgupta, learned counsel for the appellant. Order reserved.
Lordship. And I have a application, Lordship.
Okay. On next that we will consider it.
Lordship.
On next that we will consider it.
When next date, Lordship?
We don't know. We reserved the order today.
Lordship. But there are 12 is fixed for execution case, Lordship, in trial.
Maybe.
This is the whole trouble. They are pressing for that. They are not appearing here, but they are pressing there, Lordship, for execution.
No, here we have not issued notice to them.
We have everything completed, Lordship. Everything complete. Earlier notice already we have taken dusty service also, Lordship. That is already in order sheet, Lordship.
Okay.
Obliged, Lordship.